My son stood in my living room and watched, while his wife told my wife of 38 years to sign over our home or face consequences she wouldn't like. I came home 3 days later to find Carol barely conscious on our bedroom floor, dehydrated, bruised from trying to force a door that wouldn't open. She used the last of her voice to tell me 4 words that rearranged everything I thought I understood about family. Kyle did this. I spent the next 3 weeks making sure my son and his wife lost every single thing they had spent years positioning themselves to steal. I need to go back about 8 months. I spent 35 years as a financial advisor in Houston, helped families build wealth, protect assets, plan for the future. I understood money the way some people understand weather, not just the surface conditions, but the pressure systems building beneath them. When I retired at 62, Carol and I had a paid-off house in Katy, a solid portfolio, and what I believed was a functional relationship with our son. Kyle was 34, worked in commercial real estate, and had married Vanessa 3 years earlier. I'd had reservations about Vanessa from the beginning, not because of anything I could name precisely, more like reading a balance sheet and sensing something was being hidden in the footnotes. The first loan request came 6 weeks after their wedding. Kyle needed $17,000 for a business opportunity he described as time-sensitive. I asked for details. He deflected. Vanessa stepped in with polished language about market windows and first-mover advantage. I wrote the check because he was my son and because I believed he'd turn it around. He didn't. 6 months later, a quiet conversation over the phone. The opportunity hadn't materialized. He was sorry. He'd pay me back when things stabilized. They never stabilized. Over the following 2 years, the requests came with increasing regularity. $12,000 when their car was repossessed. $9,000 when Vanessa's boutique opened and immediately needed capital infusion. $22,000 when they fell behind on rent and faced eviction from their Galleria area apartment. $60,000 total, spread across 11 separate transactions, each one documented in a folder I kept in my home office filing cabinet. Every loan agreement signed. Every conversation noted with dates and amounts, old habits from the advisory business. Paper trails matter. Carol worried more openly than I did. She'd mentioned patterns I was trying not to see. How Kyle only called when something had gone wrong financially. How Vanessa steered every family dinner toward conversations about estate planning and inheritance. How neither of them had once asked how Carol's knee surgery went, but called within 48 hours whenever I mentioned reviewing my investment accounts. I listened. I told myself it was generational pressure, that they were struggling, that we needed to give them room to find their footing. Carol would look at me the way she had for 38 years when she thought I was being optimistic past the point of evidence. The conversation that changed everything happened on a Tuesday evening in late February. Kyle called ahead this time, said he and Vanessa wanted to come over and discuss something important. They arrived with a folder of their own, which should have told me something. Vanessa did most of the talking. She explained that they'd consulted an estate attorney unprompted, on their own initiative, who had advised them that the most efficient way to avoid probate complications was to add Kyle's name to the deed of our house now, while Carol and I were healthy. She had the paperwork ready, pre-filled. She set it on the coffee table like it was a formality we just hadn't gotten around to. I looked at the documents for a long moment without touching them. What exactly would this accomplish? I asked. Vanessa explained the probate process as if I'd spent my career doing something other than estate and financial planning. Kyle sat beside her and nodded at intervals. He wouldn't meet my eyes directly. That was the thing about Kyle in these moments. He was present but never quite there. Vanessa was the engine. He was the vehicle she drove. I told them I understood probate law reasonably well. I told them Carol and I had our estate documents in order with an attorney we'd trusted for 12 years. I told them that adding a third name to the deed of our home was not something we were willing to do. Not now. Not structured this way. Vanessa's expression didn't change, but something behind her eyes did. She said they'd expected resistance. She said they'd hoped we would understand that this wasn't about distrust, it was about practicality. I told her it was about $60,000 I'd lent her husband and never seen repaid. Kyle finally looked at me. I pulled out my own folder, laid out the documents the same way she'd laid out hers. Loan agreements with his signature, bank transfers, dates and amounts. I wasn't angry. I was presenting facts. After 35 years of doing this professionally, removing emotion from the delivery of difficult information had become instinct. That's not what this is about, Vanessa said. It's exactly what this is about, I told her. You want me to transfer partial ownership of a $400,000 asset to a couple carrying $60,000 in personal debt to me alone. That's not estate planning. That's asset positioning. Kyle stood, told Vanessa they should go. She gathered her folders slowly, deliberately, holding my gaze. She said that we were making a mistake. That family should take care of family. That they'd given us time to come around, and they were disappointed we'd chosen to be difficult. I told her she was welcome to take the paperwork with her, because I wouldn't be signing it. At the front door, she turned around once more. You'll regret not doing this the easy way. Carol and I stood in our entryway after they left. She hadn't said a word during the meeting. She put her hand on my arm. How do you feel? She asked. I told her I felt like a man who'd finally read the footnotes. She nodded and went to make tea. 3 weeks later, a real estate attorneys conference in Dallas. 2.5 days. Thursday through Saturday. I'd been invited to speak on a panel about succession planning for family-owned assets. The kind of speaking engagement I'd started accepting since retiring, keeping my mind engaged without the full client load. Carol drove me to the airport Thursday morning. Same ritual we'd had for years. Text me when you land. I always do. I know. I worry anyway. I kissed her and told her I'd bring back the collages from the airport bakery she liked. The conference passed the way conferences do. Sessions I found genuinely interesting, lunches I didn't taste, evenings reviewing my panel notes. I texted Carol both nights. Brief responses came back Thursday night. Nothing Friday morning. Nothing Friday evening. I called twice. Voicemail. I told myself she might have gone to her sister's unexpectedly, or her phone had died. Or she was annoyed with me about something I hadn't noticed. But Carol had never gone more than a few hours without responding to a call. Not in 38 years. I modified my Saturday flights. Got an earlier connection out of Dallas at 6:15 in the morning instead of the afternoon flight I'd booked. Paid the change fee without hesitating. Something in my chest had been tightening since Friday afternoon and I needed to move. I pulled into our driveway at 10:47 Saturday morning. Carol's car was in the garage. The mail from Thursday and Friday was still in the box at the street, including a catalog she would have brought in immediately. The porch light was on, in full daylight. I unlocked the front door and walked through the house, calling her name. Kitchen empty, coffee maker clean and dry, no dishes in the sink. Living room untouched. I moved faster through the hallway. The guest bathroom door was open. The door to my home office was open. The door to our master bedroom was closed. I tried the handle. It didn't move. I punched the code into the smart lock keypad on the doorframe. Kyle had installed it 4 months ago as a Christmas gift, said it was for our security, that we could lock the bedroom remotely if we were traveling and wanted to protect valuables. I'd thought it was a thoughtful gift. I entered the code. The lock cycled. I pushed the door open. Carol was on the floor between the bed and the window. She'd pulled blankets down from the mattress at some point. There was an empty glass on its side near her hand. The curtains were drawn. The room smelled closed in and wrong. I was on the floor beside her before I registered crossing the room. Carol. Her eyes opened slowly. Her lips were cracked and dry. Her hands, when I took them, were cold despite the warmth of the room. Raymond, she whispered. I called 911 with my phone to my ear, and my other hand checking her pulse. I need an ambulance at 14 Clearwater Bend, Katie. My wife. She's been in a closed room for at least 2 days. She's severely dehydrated and she can't stand. The dispatcher kept me on the line. I moved to the bathroom, ran a glass of water, came back and helped Carol take small sips. Her hands shook too badly to hold it herself. I steadied the glass and watched her face. Her eyes were focusing more now. She coughed. I asked her what happened. I kept my voice level the way you do when the answer is going to be something you're not prepared for. Kyle, she said. I didn't move. He came Friday morning, early, used his spare key. He had the deed papers again. Wanted me to sign before you came home. He said you'd already agreed. I helped her take another sip. I told him I wouldn't sign anything without you there. He got very loud. She paused, gathered breath. He took my phone off the nightstand. Told me I could stay in here until you came home and reconsidered. She looked at me steadily. He locked me in, Raymond. His own mother. He locked me in our own bedroom and walked out. The ambulance arrived 8 minutes after my call. The paramedics were professional and efficient. A woman named Torres and a younger man named Park, who photographed the room before helping Carol onto the stretcher, standard procedure for suspected elder abuse. Torres told me Carol's blood pressure was low and her core temperature elevated. She needed IV fluids immediately. They were taking her to Memorial Hermann. I could follow or ride along. I rode with her. In the ambulance, I held Carol's hand while the IV line was started. She squeezed my fingers with more strength than I expected. Park told me she was stable. Torres asked me questions. I answered them and watched my wife's face as the fluids began working. The color came back in increments. She had been locked in that room for 47 hours. The bedroom window faced the backyard. Our neighbors on that side, the Petersons, had a privacy fence. Even if Carol had broken the glass, unlikely given the double-pane construction Kyle had helped us select when we renovated, she would have been shouting into a fenced yard with no one home on a Friday morning. The smart lock on the door could only be opened with the code or from a phone app. Kyle had set it up. Kyle had the app. At Memorial Hermann, Dr. Anita Voss examined Carol and admitted her overnight for observation. Moderate dehydration, contusions on her hip and shoulder from falls, early signs of heat stress from a closed room. She told me that Carol would recover fully. She told me, with the careful language doctors use when they want you to hear the subtext, that another day would have complicated things considerably. I sat in the waiting room while they moved Carol upstairs. The rage I felt was not the kind that makes a man loud. It was the kind that makes a man precise. I'd seen the same thing in clients who'd been defrauded. The fury that comes not from surprise, but from the confirmation of something you'd been hoping you were wrong about. I wasn't wrong. I'd just been too patient. I called Detective Sergeant Elaine Crawford at the Houston Police Department. I'd met her twice at community planning meetings over the years. She wasn't homicide or robbery, but she knew who was. She answered on the third ring and listened to what I told her without interrupting. When I finished, she was quiet for 2 seconds. "I'll get someone from Family Crimes to call you within the hour," she said. "Document everything before you go back to that house. Don't touch the door lock." I photographed everything on my phone before the detective arrived. The bedroom door with the smart lock, the glass on the floor, the blankets pulled down, the closed window, the nightstand where Carol's phone had been taken. I pulled up our home security app. We had exterior cameras and captured footage from Friday morning. 7:42 a.m. Kyle's truck pulling into the driveway. 8:16 a.m. Kyle's truck leaving. 47 hours before I came home. Detective Marcus Webb from the Harris County Family Crimes Unit arrived at my house at 2 that afternoon. He was thorough and unhurried, worked through the house systematically, photographed and collected. He swabbed the smart lock keypad. He reviewed the security footage on my phone and made copies to his department tablet. He asked me twice, gently, if I was certain it was my son who had done this. I told him I was certain, and I told him why. He told me what I already knew: false imprisonment, elder abuse under Texas Penal Code, both felonies depending on circumstances. He'd file the report and have Kyle brought in for questioning, most likely by Monday morning at the latest. I visited Carol that evening. She was propped up in bed with better color and an IV still running. She looked at me for a long moment when I walked in. "Did you call the police?" she asked. "Yes." "Good," she said. And then, softer, "He's still our son, Raymond." I sat beside her and took her hand. "I know that. I also know he locked you in our bedroom for 2 days and walked away. Those 2 things can both be true." She nodded. She didn't ask me to go easy. Sunday I spent at the kitchen table with a yellow legal pad. Old habit. When I needed to think clearly, I wrote by hand. I listed every available avenue in 3 columns: criminal, civil, financial. Criminal prosecution was already moving. Civil lawsuit, intentional infliction of emotional distress, false imprisonment, elder abuse damages. Financial, review and revise everything. Will, beneficiary designations, the investment accounts, all of it. Monday morning, I was in the office of Patricia Huang, an attorney I'd referred clients to for over a decade but never personally needed. She was sharp and direct and did not soften what she told me. Based on the evidence, the security footage, Carol's medical records and the loan documents I'd brought with me, I had an extremely strong civil case. She suggested a demand of $140,000 medical costs, pain and suffering, damages, and told me the loan agreements alone constituted additional civil liability. She also strongly recommended immediate estate document revision. I told her to start on the civil complaint. Then I called Gerald Marsh, our estate attorney, from the parking garage. He had me in his office by 2 that afternoon. I sat across from him and told him what I wanted with no ambiguity. I want Kyle removed as a beneficiary entirely. I want the language explicit, not omission, not a nominal amount. Explicit language stating that he is intentionally excluded based on his actions. Everything goes to Carol. If Carol predeceases me, everything goes to the Texas Children's Hospital Foundation and the Harris County Elder Justice Initiative. Not a dollar to Kyle, not a dollar to Vanessa. Make sure it holds up to any challenge. Gerald made notes. He drafted while I waited. 2 hours later, I signed documents that unmade 30 years of estate planning in Kyle's favor. The old will went through the shredder. I watched it go. That evening, my phone rang. Kyle. I'd been waiting for this. I let it ring 4 times before answering. Dad. His voice was unsteady. I heard what happened. I know you found Mom. Is she okay? She's in the hospital. Dehydration. Bruising. The doctor said another day and we'd be having a different conversation. Silence. I know how it looks. I didn't mean for it to go that long. I thought you'd come home sooner. I just needed her to stay there until you got back and we could talk rationally about the house. You locked your mother in a room without water and took her phone. She wouldn't listen to me. She's your mother. She doesn't have to listen to you. Dad, please. I panicked. I wasn't thinking clearly. Vanessa and I are in serious trouble financially, and I thought, if we could just get the deed transfer done. You thought you could extort me by imprisoning my wife. Don't call it that. That's what the detective is calling it. False imprisonment, elder abuse, those are the charges being filed. His breathing changed. Charges. Dad, come on. I'm your son. Please don't do this. We can fix this. You locked your mother in our bedroom for 47 hours. There's nothing to fix. I'll pay you back. Everything. The $60,000. I'll set up a payment plan. I'll get a second job, whatever you need. Just please don't file charges. The police file charges. I filed a report. That machine is already running. Then tell them you made a mistake. Tell them it was a family misunderstanding. They'll listen to you. I won't lie to the police on your behalf. His voice broke. Dad, please. I'm begging you. This will ruin my life. You made a choice when you locked that door. Every consequence that follows belongs to you. I ended the call. Let the phone ring 3 more times after that. Didn't answer. Then I blocked the number and went to bed. I slept better than I had since Thursday. Carol was discharged Tuesday morning. I picked her up and brought her home. I'd changed the code on the smart lock and scheduled a locksmith to replace it entirely. The room was clean. Fresh sheets. Water on the nightstand. She stood in the doorway for a moment, looking at the space where she'd spent 2 days on the floor. Then she walked in and sat on the edge of the bed. Tell me everything, she said. I told her. The will revision, Patricia Huang, and the civil complaint, Detective Webb, and the criminal investigation. She listened with her hands folded in her lap. When I finished, she was quiet for a moment. The house, she said finally. Are we going to lose it because of the deed thing? No. I explained why the unsigned documents meant nothing. The deed was ours, always had been. There was no legal mechanism by which Kyle could have transferred ownership without my signature and Carol's. Vanessa had known that. The pressure campaign, the loans, the isolation, the deed documents, finally the imprisonment, had all been aimed at the signature they couldn't take. They'd overplayed their hand. Carol exhaled slowly. Then they did all of this for nothing. For nothing. Tuesday evening, Vanessa called from an unknown number. I answered because I recognized the Houston area code pattern she'd used before. She was crying before she'd finished saying my name. Clark, please. She used my name incorrectly and didn't notice. We're going to lose everything. Kyle's going to be arrested. Please just drop this. It was a terrible mistake. He didn't mean to hurt her. Kyle locked my wife in a room for 2 days without water. Intentionally. With planning. He drove to our house, let himself in with a key I gave him in trust, took Carol's phone, locked the door using an app on his phone, and drove away. That is not a mistake. That is a sequence of deliberate choices. She was just supposed to call you. Kyle panicked. You weren't supposed to be gone so long. My schedule is not relevant to what your husband did. We don't have any money. She was crying harder now. There's nothing left. The boutique failed. We owe everyone. Kyle is probably going to lose his job when his employer finds out about the charges. We have nowhere to go. I thought about the financial investigation report my private contact had put together over the weekend. Kyle and Vanessa's combined debt was just under $90,000, 2 maxed credit cards, a personal loan in collections, unpaid boutique vendor invoices totaling $18,000. Their lease was up in 6 weeks. The deposit they'd paid was already being applied to back rent. You've known about my investigation, she said. Her voice shifted. That's invasion of privacy. Everything in that report is public record and lawfully obtained in preparation for civil litigation. You're going to destroy us. You walked into my house and told my wife she'd regret not doing things the easy way. Then your husband made sure she regretted it. We're sorry. We are genuinely sorry. Please just let us apologize to Carol. She'll understand. She's always been more reasonable than you. Carol is not available to be appealed to. Neither am I. I ended the call and blocked the number. Detective Webb called Thursday morning. They'd brought Kyle in Wednesday afternoon for questioning. He'd initially tried to characterize the incident as a misunderstanding, a family dispute that got out of hand. When Webb presented the security footage, the smart lock access logs showing Kyle's phone had engaged the lock at 8:12 Friday morning and not disengaged it until I opened the door Saturday, and Carol's medical records. Kyle's attorney had stopped the interview. The Harris County District Attorney's Office reviewed the case file Thursday afternoon. False imprisonment, a third-degree felony under Texas Penal Code 20.02. Elder abuse, a second-degree felony under Texas Penal Code 2204. Given Carol's age and the severity of her physical condition. Kyle was arrested Thursday evening and booked. Bond was set at $30,000. I learned about the arrest from Webb. He called me as a courtesy. I thanked him and sat with the information for a moment. Then I walked to the kitchen where Carol was reading and told her. She set her book down, closed her eyes briefly, opened them. Then she picked up her book again and didn't say anything else about it for the rest of the evening. I understood that silence completely. Friday afternoon, Vanessa's mother called. I recognized the Georgia area code from a birthday card Kyle had once asked me to address. She identified herself as Donna. Her voice was controlled, but barely. Mr. Henderson, I'm calling because I don't know what else to do. Vanessa is my daughter, and I love her, but I also know that what they did to Carol was wrong. I understand you're pursuing this legally, and I'm not calling to ask you to stop. She paused. I'm calling because I want you to know I'm ashamed. And I wanted to tell you that directly. That was not what I expected. I told her I appreciated her saying so. She told me she'd learned about the financial situation the previous night, that Vanessa had been calling her for 2 years asking for money, that she'd given what she could, but had learned to set limits, that she didn't know about the deed scheme or about what Kyle had done to Carol until yesterday, when Vanessa called from the police station. I told her Carol was home and recovering. She said she was glad. She said she hoped I'd be able to find some peace when this was over. I told her I thought I would. She said goodbye, and I believed she meant it. Kyle posted bond Saturday with help from a college friend. Patricia Huang filed the civil complaint Monday morning. Service was achieved by Tuesday, delivered to Kyle's attorney's office. Tuesday afternoon, Kyle called Carol's phone, which violated the no-contact condition of his bail. He was detained and held for 18 hours before his attorney resolved it. The violation was noted in his file. The weeks between the arrest and the trial date move the way these things do when the evidence is overwhelming and the defendant's resources are exhausted. Kyle's employer, a commercial real estate firm in the Galleria, discovered the felony charges through a routine employee screening update and placed him on unpaid administrative leave within 10 days. Vanessa's attempt to negotiate a sublease on their apartment failed when the prospective tenant ran a background check and learned about the pending charges. 6 applications to new apartments were rejected in succession. Patricia Huang received a call from Kyle's civil attorney in late September. They were prepared to offer a settlement. Kyle and Vanessa had liquidated the last of their joint savings, borrowed against a small life insurance policy, and assembled $11,000. They were offering this amount in exchange for dismissal of the civil suit, along with a formal written apology, a notarized admission of liability, and a signed waiver of any future claims against our estate. Huang called me. She was clear-eyed about it. We'd never collect the full $140,000 regardless of what the judgment said. They had nothing. The $11,000 was symbolic, but the other terms were significant. Formal admission. Permanent estate waiver. Apology on the record. It was, she said, a complete surrender. I thought about it for one day. Talked it over with Carol that evening. She said she didn't want the money. She said she wanted it to end. I told her ending it on these terms wasn't forgiveness. It was accounting. The debt acknowledged, the ledger closed. I accepted the settlement. The civil hearing was on a Wednesday morning. Carol insisted on coming. She wore the blue dress she'd had for 20 years. We drove downtown together and didn't talk much. At the courthouse, we walked through security, took the elevator, found the correct courtroom. Kyle and Vanessa were already seated when we arrived. Kyle wore a suit that didn't fit well. He'd lost weight since the spring. Vanessa sat close to him, her posture rigid. Kyle looked at me when we walked in. It was brief. His eyes were somewhere between hollowed out and resigned. He looked away first. Judge Reyes conducted the settlement hearing with efficient professionalism. Huang presented the terms. Kyle's attorney confirmed acceptance. The judge reviewed the admission of liability and the apology statement Kyle was required to read into the record. Kyle stood with a paper in his hand. His voice was flat. He read that he, Kyle Henderson, admitted full responsibility for imprisoning his mother, Carol Henderson, in her home bedroom on the 14th and 15th of March for a period of 47 hours without access to food, water, communication, or means of escape, and that this action had caused her severe physical and emotional harm. He said he was sorry for what he had done. I watched his face while he read. There was no relief in it, no genuine remorse. What I saw was a man reading words he had to read in order to make something stop. That was fine. I wasn't there for his feelings. I was there for the record. Judge Reyes signed the settlement order. The gavel came down. 13 days later, Kyle entered a no-contest plea on both criminal charges in Judge Warren's courtroom. The plea agreement had been negotiated by his public defender. He'd exhausted his private legal funds weeks earlier. 3 years probation, 240 hours of community service, mandatory counseling, permanent protective order in Carol's favor. If he violated any condition, immediate incarceration with a sentence of up to 12 years. No contest means he did not admit guilt in the criminal proceeding. But combined with the civil admission signed 6 days earlier, the record was complete. Anyone looking would see the full picture. At the criminal sentencing, I sat in the gallery with Carol. Kyle stood before the judge and answered questions in a flat, cooperative tone. He said he understood the terms. He said he understood the consequences of violation. When Judge Warren asked if he had anything to say, Kyle turned briefly and looked in our direction. His mouth opened slightly. Then he turned back to the judge and said no. Outside the courthouse, walking to the car, Carol and I passed through the broad mid-morning sunlight. She held my arm. I asked her how she felt. She thought about it for half a block. Like something heavy has been put down, she said, that I've been carrying for a long time without noticing. I understood exactly what she meant. That evening, I opened my laptop and found the folder I'd labeled Evidence March 2025. Civil complaint. Criminal charges. Security footage archive. Medical records. Detective reports. Settlement agreement. Plea agreement. Sentencing documentation. I created a subfolder, moved everything into it, and labeled it Closed. Then I closed the laptop and went to the back porch, where Carol was sitting with her tea watching the last of the evening light move through the yard. The neighborhood was quiet. Someone's lawnmower running 2 streets over. A cardinal working through the feeder Carol had maintained for 15 years. I sat beside her. We stayed there until the light was gone and the air turned cool. We talked about the things we'd been putting off planning. A trip to Oregon to see her sister. A kitchen renovation we'd discussed for years but never started. A weekend in Fredericksburg that neither of us had gotten around to booking. We didn't mention Kyle. We didn't need to. That account was settled. In 35 years of financial advisory work, I had told clients more times than I could count that the goal was not to let a bad investment define your portfolio. You document the loss. You close the position. You reallocate toward what still has value. Carol reached over and took my hand. The cardinal came back to the feeder, bright against the darkening yard. We had plenty of value left to work with. Before we continue, if this story resonated with you, please subscribe to the channel and let me know in the comments what time is it where you are right now and what would you have done differently.